Begin the recording. Good morning. My name is Ria, and I'm an intern at Thomas George and Associates. On behalf of Thomas George and Associates, I cordially welcome you all to the third National Virtual Moot Court Competition. We are pleased to extend a warm welcome to Advocate Satya Siri and Manish Sharma as our judge today. Satya Siri has been a practicing advocate based in Hyderabad. After graduating from Nalsar University Law, she enrolled with the Bar Council of Andhra Pradesh, now Telangana, in June 2015. Thereafter, she has obtained her LLM from University of Pennsylvania Law School, specializing in areas of international commercial law and alternate dispute resolution. Manish Sharma is an advocate on record in Supreme Court of India and has a practice of 10 years. He has completed his BA LLB from Guru Gobind Singh Indraprasth University, Delhi in 2011 and holds a PG diploma course in intellectual property rights from Indian Law Institute. He has also completed his post-graduation in intellectual property law from the George Washington University Law School, USA in 2012. He's registered with the Bar Council of India since 2011 and is also a member of New York Bar. Now I shall proceed to explain the time division. I'm so sorry. I think TGA 16 has left the meet. We'll wait for 5 minutes for them and then I'll continue explaining the time division between the teams.
Sure, yeah.
Okay, all right. So I'll continue explaining the time division granted to the teams. Each will be allocated 30 minutes to present their case. Speaker will be given 15 minutes unless otherwise is indicated by the team. Placards indicate time would be shown 3 minutes prior to the lapse of the allocated time, as well as when the entire time has lapsed. 30 seconds would be allocated for rebuttals and sur-rebuttals. We have team TGA 16 representing the petitioners and TGA 12 representing the respondents. With the permission of the learned judges, we'll commence the quarterfinals of the third National Virtual Moot Court Competition. Can we begin? Right. Petitioners Council, you may proceed after confirming your preferred time division.
We'll go with 15 minutes per person.
All right. So I'll give you a countdown. Okay. Are you ready?
Counsel for petitioner seeks extension of just 5 minutes before beginning the session. Is it allowed?
I don't think it's allowed. You have begun the session. What is the issue? You can tell me. Is there a connectivity issue?
Okay, fine. We'll start.
Okay, I'll give you a rundown of 3 seconds. 2, 1.
Okay. Counsel for petitioner seeks permission to approach the dais.
Please.
Counsel for petitioner seeks permission to state the facts.
Go ahead.
Counsel for petitioner seeks permission to address the bench as your lordship and your ladyship together as bench.
Go ahead.
The Republic of Parlamento is the largest democracy of the world with a population of around 140 crores. The Republic of Parlamento is thus a secular, socialistic, economic, and democratic nation. During the 2020, the entire world was hit by COVID-19 pandemic, and during the said period, the digital transactions increased manifold, and digital assets have been rise in the recent times. The Republic of Parlamento did not enact any law to legalize the framework of digital assets, digital currency, non-fungible tokens. An attempt to ban these forms of virtual currency asset was set aside by the Honorable Supreme Court of Republic of Parlamento. While the government continues to contemplate its stances on cryptocurrencies and NFTs, it has the interim implemented a new tax regime, which is a 30% tax on the virtual digital assets. But the citizens were perplexed as to when there is no law to legalize the digital currency, NFTs, and VDAs. And how can the government tax them based on the gains that they receive from these currencies, which is the digital currency, digital assets, and the NFTs? Thereafter, various citizens filed a writ petition before the Honorable Supreme Court challenging the insertion of Section 115 BPH of the Income Tax Act. Counsel for petitioner seeks permission to begin with the advanced arguments.
Yes.
Thank you, Your Lordship. Whether or not the government is justified in taxing digital currency, digital assets, NFTs, which is not legalized. Section 2 of the FEMA Act of 1999 defines currency. Now, this includes currency notes, postal orders, money orders, check drafts, traveler's check, letters of credit, bills of exchange, and promissory notes, credit cards, and other similar instruments which are notified by the Reserve Bank of India. In the case of MK Bros Private Limited versus Commissioner of Tax UP, it was held that the Supreme Court held that the nature of transaction, which depends on the purpose of which the payment has been made and the expenditure incurred. Now, it is on the similar lines that these cases where a taxpayer may acquire an asset not with the idea of selling it at a profit at the later point of stage, but then to retain it as its own investment. Now, in such cases, the profit or gain which is derived from the sale or any other transfer of such investment of that nature would constitute a capital profit, and this cannot be charged to tax under the head of income from business or other profession. However, we state the fact that the asset concerned was originally acquired. So in this particular case, it was originally acquired with the intention of selling it to make a profit out of the sale, but it is considered to be immaterial as per the court for the purpose of assessment in order to charge to levy the 30% tax on it. Here, the law is settled that in order to determine that an asset is a capital asset or forms a part of the stock in trade, it is the intention which matters that is to be considered. And mere holding for property of or investment cannot amount to business. Now, before you tax, it is the four heads which are considered, which is so which is the profits from business, gains, or income from other heads, and so here the person who has merely invested his shares for the purpose of earning dividends and does not carry business is still asked to pay tax. But this, as per the definition, this does not fall under the heads of taxes, which is for the purpose of earning profits or gains. And in case the original person had an intention to resale at a later point of time, it is the intention which is to be considered. Now, cryptocurrencies such as the Bitcoins or Ethereum are digital or virtual currencies that use cryptocurrency for security, are not backed by the government or the central government. Now, they are considered to be legal tender in India, meaning that they cannot be used to pay for goods and services in our country. So in the year 2018, the Reserve Bank of India, which is the RBI, issued a circular prohibiting the regulated financial institutions from dealing with or providing services to individual or businesses dealing in virtual currencies. Now, by this means of circular, they say that the use of cryptocurrencies is not illegal in India, but they're at the same time, they're not recognizing this as a legitimate form of payment as well. And since there is no law that regulates cryptocurrencies as a legal business, the outset of this, it is respectfully submitted that on behalf of the Republic of Parlamento, by pleading to quash the impugned, that is Section 115 pph and Section 247A of the Act on the grounds of unconstitutionality. It is being taxed, that the people are evading such income from being taxed. Now, therefore, the following paragraphs, which is now on the basis of a GARC committee report of 2017, which studied the issues relating to VC and VDAs. VDAs is the virtual digital assets and the virtual currencies. They proposed certain recommendations, which is on regarding the certain risk and regulatory challenges where elusive. Now, under the spectrum of legal and regulatory risk, and coming to the clarity of ownerships and due diligences are required in terms of recommendations that RBI focus on building appropriate regulations. Now, owing to this, in the digital age, VC and VDA are not backed by the government, which is the virtual currencies and VDAs. And RBI issued a circular regarding the ban of cryptocurrencies. But then this was not passed, and they issued the circular initially with respect to the terrorism activities which would be conducted, or hacking which can take place because of the use of cryptocurrencies in the digital age during pandemic. And since this circular was not, didn't come into picture, it was banned, they do not have a legal stance on the basis of which they can impose this 30% tax. In the case of non-estates versus private limited versus CIT, the court held that the word investment must be constituted in the ordinary popular sense of the word, as used by businessmen and not as a term which is being defined or technical meaning. Now, in the case of cryptocurrency taxation, there's this one concept called Nash equilibrium, which occurs in only one case that indicates that cryptocurrencies should be taxed with low rates and high penalty rates. But the government is clearly silent and silent on the legal status, whilst also not declaring it illegal. And the Republic of Parlamento is proceeding to levy the 30% charge or tax without even legalizing its status over here. It is clear that there is no consensus among the Republic of Parlamento and the citizens about the legal status and the taxation process of the cryptocurrencies. In the case of CIT versus BC Srinivasa Shetty, the court held that the cost of acquisition is indeterminable because no capital gains would be taxed. This seems to be a major loophole. We bring to the notice of Honorable Court that in the case of Amit Bhargava versus Union of India, where the Supreme Court asked the Government of India to classify the legality of cryptocurrency, and the government is yet to give a clarification on basis of on this particular aspect. In the case of A.V. Fernandez versus the state of Kerala, the Supreme Court also held that no tax can be imposed by inference or by analogy or by trying to probe into the intentions of the legislature and by considering what was the substance of the matter. The Apex Court has again affirmed the view that cryptocurrency cannot fall under the ambit of this act in the case of Shankara Rao Badam and others versus the state of Mysore and another. Now, virtual currencies require different treatments, as not every currency is of a fixed price and they're sold at completely different value. So let's say, for example, this person gets a 2 lakh rupees profit while trading the cryptocurrencies and intends to invest 50,000 rupees and undergoes a loss in NFTs and then further invest 50,000 rupees from that 2 lakhs and again undergoes a loss in VDAs. Now, as per the general calculations of the government, which is the 30% tax, the 30% would be levied on the 2 lakhs. Now, according to the calculations, this person is in reality suffered loss from investing in NFTs and VDAs. The government is not clearly concerned about the losses this person undergoes, but only the profit which is initially shown. So the actual result is not on basis of which the tax is being assessed. And owing to the implication of the decision which was mentioned in a CIT versus BC Srinivasa Shetty again, citing this judgment once again, here the legislature had amended Section 55, which contained the meaning of cost of acquisition, which is under Section 55, Clause 2 of the Finance Act of 1987. Yet after this amendment, the cost of acquisition for the capital assets, where there is no cost or it was difficult to ascertain the cost, was to be taken as nil, and therefore the entire amount of capital gain was taxable here. Council seeks permission to rest the arguments.
Okay.
Secretary, do you have any questions for them or?
Yeah, I do have a couple of questions, but I was waiting for both the councils to finish their arguments.
Sure, we can do that and we'll put the questions. The
Yeah.
second, your colleague can start now if she's ready.
Thank you.
Council seeks permission to start with the arguments at once.
Please begin.
Second, we have 3 minutes remaining. So should I add it to the second speaker's timing or should we give only 3 minutes?
3 minutes.
No, I'll continue with my 15 minutes. only.
Okay.
Okay.
Rundown of 3, 2, 1.
Yes.
So I'll be dealing with the issue 2, that is whether or not Section 115 of the Income Tax Act is violative of Constitution of India. So Section 115 is an act which has been passed recently, which imposes tax on virtual digital assets. So there is no as such law which has been passed to give the legality of the virtual digital assets. And there is, even in the case of Internet and Mobile Association versus RBI, the court did not actually give legality of the VDAs. So there is a loophole for the VDAs that it could be illegal also. When it is illegal, then the tax on which the government has imposed tax will also not be considered, as it is violative of Constitution of India. And the tax imposed and the government has no legislative competency to impose tax on these virtual currencies, because there is no as such law pertaining them to be legal. So the government basically does not have any legislative competence to impose the tax. And in the Schedule 7 of the Indian Constitution states that the legislature has power to take action in relation to currencies or money as a legal tender. But here the cryptocurrencies are not being termed as a legal tender. So the legislative does not have a power to impose tax on those monies which has not been termed as a legal tender. And in the case of CI2 versus Srinivasa Shetty, in this it was held that the cost of acquisition is indeterminable and the capital gains cannot be taxed. Even the cryptocurrencies falls under the term of capital gains, and the capital gains cannot be taxed as per this was held in the case of CI2 versus Srinivasa Shetty. And the RBI has the power to deal with all the financial institutions like currencies and all. So here the cryptocurrency is termed as a currency in the Section 2 of FEMA Act, and the RBI has the power to impose restrictions on trading of any currency which has been taking place. So in that in Internet and Mobile Association versus RBI, the RBI has passed a circular banning the cryptocurrencies, but the Supreme Court did not ban the cryptocurrencies, but even they did not term them as illegal. The RBI has the power to control these private cryptocurrencies which has been taking place in India. So, and also in the National Provincial Bank versus Ainsworth case, the court further noted that cryptocurrencies are not legal tender in the sense of being a regulated currency issued by the government, but do not have a fundamental characteristics of intangible property as being an indefinable thing of value. So here they have no legal status. If there is no legal status, first the government has to legalize the cryptocurrencies and they can tax it. So in this, when the validity of enactment is in question, the first thing for the court to do is to examine whether the act is a law with respect to a topic assigned to the particular legislation which has been enacted. So in this, the government does not have any legislative competency to impose taxes on these cryptocurrency which has not been legalized, and it will be ultra vires the constitution. Council seeks permission if the honorable judges are satisfied so that I can move to the prayer.
Mr. Manish, do you want to start with any questions? Or
I believe we have questions, so we'll just put those questions, and if you guys can comment on those specific queries, then we can move to the prayer after that. So one thing which I would like to hear you from would be, if you keep on saying that it is like the RBI by its circular has, they did try to ban the cryptocurrencies, which was shot down by the Supreme Court. Question is, if that notification was shot down, does that automatically mean that the cryptocurrency would per se be legal? And number one, I can understand that it's not regulated. There is no legislature which is regulating them, but does not mean that it is illegal also. It may be regulated by certain act, but does not mean it's, because it's not regulated, it's per se illegal. So if you can shed some light on that point.
Yes, Your Honor. Counsel for Petitioner seeks permission to be.
One second, Satyasri, if you also have any queries, you can also raise them. They can probably give an.
yes, I have a couple of questions. You said that the union does not have legislative competence. Could you expand on that? Why are you saying that there is no legislative competence to make such a law taxing cryptocurrencies or any kind of digital currencies? For the fact that they are not taxing acquisition, or they are not taxing the section 115 BBH does not seek to tax cryptocurrency as such. It seeks to tax, from my understanding, it seeks to tax the profit gained by any person, individual or company upon transactions relating to cryptocurrency, right? So let's take an analogy of shares, for example, of any other intangible asset for that matter, where there is a law that if you're seeking, for example, you spend X amount of money in acquiring a particular asset and you sell it for X plus 1, then the plus 1 is what is taxed. Right. So why I'm trying to understand on that aspect why you're saying that there's no legislative competence. Again, even if as Manish sir has said, yes, okay, just because it's not regulated does not mean that it is illegal. On the second hand, even if it is illegal, why can't there be a tax on it? The illegality and the taxation are completely different aspects. So please explain in that circumstance why it should not be taxed. The third thing, the Srinivas Shetty case that you seek to rely on, is talking about, it is a judgment which talks about when you can't figure out what is the cost of acquisition, then it can be taxed. But here it would be very clear what the cost of acquisition is, because what you're paying for the value is the cost of acquisition. And then there's the next amount that you're paying for purchasing a particular digital currency, and then you're selling it for so and so amount. So on these three aspects, if you could just clarify.
Okay, I would like to answer the second issue, which is that why there is no legislative competence to impose tax. So in the 7th schedule of Indian Constitution, it speaks that the legislature has the power to take action in relation to currencies or money which is termed as a legal tender. So cryptocurrencies has not been termed as a legal tender. So this schedule is like a restriction on Article 265, which gives power to the state legislature to impose tax. So this is like a restriction on the 265 of article, because it states that only it can impose taxes on the currencies or money which has been termed as a legal tender, and cryptocurrencies has not been termed as a legal tender.
Counsel for petitioner seeks permission to begin to answer the question.
Please.
So with respect to the circular issued by RBI, there was no proportionality, that it did not have the legislative power prohibiting the trading of virtual currency. Besides, it also violates the article of 19(1)(g). And since this circular did not ban it completely, so again.
So here the Supreme Court, in this case, the Supreme Court did not, so the Supreme Court quashed the order of banning the cryptocurrencies which has been issued by the RBI. So here the Supreme Court even did not term the cryptocurrencies as legal. So there might be some loophole because of which the Supreme Court did not term it as a legal or illegal thing. So it doesn't mean that Supreme Court has like quashed the order of banning, but it did not term it as a legal currencies.
Does Supreme Court have the power to give such legality?
They can shoot down a notification, a law, an act saying whether it's legal or not per se to a constitution, but they cannot, of course, go and say this is legal or illegal. That is the scope of the legislation. So, like my learned colleague, she's rightly pointing out, can the Supreme Court do that? If they want to say if it's legal, can they do that?
Counsel for the petitioner is unaware of this. Apologies, Your Lordship.
It's okay. Anything else you guys want to add?
Answering the last question regarding the Srinivas City case. So in this case, as ma'am rightly pointed out about the cost of acquisition, which can be determined, but since this is a virtual currency, here not every currency has a fixed price, because if I purchase it at a particular price and I sell it to some other person at a completely different price. So in this case, when it is sold, it is at a completely different value. So you cannot have one particular tax for, let's say, one set of transactions. For example, if you're selling a house, so there is a certain percentage of tax based on the measurement of the house, the property. So when it comes to virtual currencies, every currency has a completely different price. And again, when they invest it, there's no specific, you can't even probably expect that there would be a profit or loss. So again, here the government is taxing irrespective of the loss as well. So, and again, capital gains. And cryptocurrency is termed as a capital gain is termed as a cryptocurrency. And in this particular case, it was held that capital gains cannot be taxed. Counsel for petitioner is done answering the question.
No, my question was, how are the facts in this case, Srinivas Shetty case, applicable to the fact situation here? Or the ratio laid down by the Supreme Court and Srinivas Shetty applicable here? Because my question is, it may be any amount of money, right? Your currency, you're spending rupees. When you're spending it, for example, in rupees, you're buying it for 10 rupees, let's say one cryptocurrency, and you're selling it for 12 rupees or 15 rupees. So what is sought to be taxed is the 2 rupees or 5 rupees, whatever is your profit. Where there the cost of acquisition is clear. So how is the judgment in Srinivas Shetty applicable in this fact situation?
Your ladyship, in this case, it was held that since currency is a capital gain, and in this case, it was held that capital gains would that no capital gains would be taxed. This is the judgment of this particular case, that since cryptocurrency is also a sort of capital gains, and in this case, it was held that capital gains would not be taxed.
Okay.
Yeah, thank you. A consular petitioner seeks permission to start the plea. Wherefore, in the lights of issues raised, arguments advanced, and authority cited, it is humbly prayed that this honorable court may be pleased to hold a judge and declare that the government is not justified in taxing digital currencies, digital assets, NFTs, which are not legalized, and Section 115 BPH of the Income Tax Act is violative of the Constitution. Also, the Honorable Court may pass any order which the Honorable Court may deem fit in the favor of the petitioner to meet the ends of equity, justice, and good conscience. For the act of kindness, the petitioner shall bound forever, duty bound forever, pray. Thank you.
Okay. Respondents will be starting now.
Can we begin? Court Master, are we allowed to start now?
Just tell me your time division. 15.
We'll be sticking to the general time, and whatever time is remaining out of our portions, we'll utilize that for the rebuttal and sir rebuttal.
The rebuttal and sir rebuttal is only 30 seconds.
Yeah, but I guess it'll be cut down short. The arguments may be of a shorter duration, but as of now, we'll stick to your time durations.
Okay. I'll give you a rundown of 3 seconds. 3, 1.
A very good afternoon to the bench and my learned oppositions. With the permission of the bench, I would like to address the bench collectively as your lordships for the course of this argument.
Sure.
This is counsel number 1 appearing on behalf of the respondent in the present matter. If your lordships are versed with the facts of the case, I would like to discuss the issues at hand.
Go ahead.
So before going into the first issue, this counsel will speak about the maintainability of the present petitions before the Honorable Supreme Court. So as it is contended that the petitions are not maintainable under Article 32, because the main requirement under Article 32 is that there must be a violation of fundamental rights. In the present case, there are no violation of fundamental rights, as it is a well-settled position of law that the mere imposition of a strict tax is not violative of the fundamental rights enshrined under Part 3 of the Constitution. To this aspect, in the case of Federation of Hotel and Restaurant Association of India versus Union of India, the court held that a taxing statute is not per se a restriction of the freedom under Article 19(1)(g) of the Constitution. The policy of a tax in its effectuation might, of course, bring in some hardship in some individual cases, but that is inevitable. The mere excessiveness of a tax or even the circumstances that its imposition might tend towards the diminution of earnings does not per se constitute violation of Article 19(1)(g). Therefore, in the instant case, the petitions are not maintainable. So moving to the first issue at hand, which is whether or not the government was justified in taxing these digital currencies, digital assets, NFTs, etc., which have not yet been legalized. Through the course of my arguments, I would also answer a few of the queries which are raised by the opponent counsels in their arguments. So firstly, it is a well-settled matter that the parliament has the power to impose tax upon any income, and it is not concerned with the legality of such income. And the same power rests with the income tax authority as well. So to this aspect, we have various Supreme Court precedents which enunciate this. So for example, we have CIT versus Thangamani, wherein the income tax authorities are not concerned about the manner or means of acquiring income. The income might have been earned illegally or by resorting to unlawful means, and illegality tainted with the earning has no bearing on its taxability. In the case of CIT versus SC Kothari, it was held that it is well settled in the English law that even if a trade is illegal, it is still a trade within the meaning of the Income Tax Act, and its income, profits, and gains are chargeable with income tax. And in Anirudh J. Solanki versus the Assistant Commissioner of Income Tax, even though it was held that even though assessees was doing an activity without the license of the competent authority, but what is mandated in the provisions of the Income Tax Act is to tax the income of the assessee, whether it was from legal or illegal source. So the main object behind imposition of a tax and the main object behind the Income Tax Act itself was to levy, administer, collect, and recover taxes in India. Moreover, to discuss upon the competency of the Parliament, the Parliament has enshrined powers under Article 265 of the Constitution, wherein it has the authority to impose the present tax. And to substantiate this, a reading of Article 248 of the Constitution, which provides the residuary powers upon the legislation, as well as a harmonious reading with entry 82 and entry 97 of list 1 of the Constitution are to be considered. Entry 82 basically discusses taxes on income other than agricultural income, and entry 97 pertains to any other matter not enumerated in list 2 or list 3, including any tax not mentioned in either of those lists can be taxed upon by the Parliament. And if your lordships permit, I would like to respond to one of the contentions which was raised by my learned opponents.
Yes.
So my opponents discussed till the midway point of the history of cryptocurrencies in India. So their arguments placed discussions only up till the point of the IMA judgment, wherein the IMA struck down the 2018 circular of the Reserve Bank of India. However, it is pertinent to note that in 2021, RBI subsequently issued another circular in which it stated that entities regulated by it must not cite the 2018 circular in light of the Supreme Court judgment. And it stated that these entities could proceed with the trading activities subject to fulfilling some conditions such as the KYC norms, the AML norms, and the CFT norms to combat financial terrorism and money laundering, etc., etc. And thereafter, the government has been contemplating to introduce the new bill on cryptocurrencies. And thereafter, we had the Finance Act, through which the Section 115 BBH was implemented. And it is to be noted that as an international economic country, the Republic of Parlamento has a very strong economic policy and a good stance at the international level. So it is important to consider the position of other governments and other countries across the world with regard to cryptocurrencies and how India and how Parlamento is moving forward with this. So if we take, for example, in Japan, in UK, and as well as in Canada, the governments, the central authorities have recognized the transactions and have accordingly taxed them. And therefore, the government is of the opinion that irrespective of the legality or illegality of the mode of income, as long as income has been generated, it is important to tax the same. With this, the council will be resting its argument, and I hand over the forum to my second counsel.
The council seeks permission to address the floor.
Yes.
This council will be dealing with the second issue, which relates to the constitutional validity of Section 115 BBH. This council vehemently contends that Section 115 BBH is not violating of the Constitution as it possesses the legal competence and also does not violate the fundamental rights enshrined in the Constitution. The council first will be dealing with the first ground, which is the legal competence. As my co-counsel already mentioned and discussed, a tax is levied with the competence as it invokes 246 of the Constitution, which deals with the residuary powers, to be read with entry 82 and entry 97 of list 1 of Schedule 7. This residuary power provides us a wide and copious power to tax different incomes. So the only question regarding to the legislative competence is that whether it falls under the list 2 or list 3, which deals with state list or the concurrent list. If it does not fall either the state list or the concurrent list, the parliament has the power to bring up any act under its power. So a brief reading of entry 97, read with Article 246, makes it clear that the constitution makers took care to ensure that the parliament has the authority to enact laws regard to any issues that until that day of constitution, it has not been perceived by the legislation and has been left out of list 2 and list 3. This case of VDS falls under the same argument. So again, reiterating, when the bias of the parliament is challenged, the only question to the court has to answer is whether the subject matter of that falls under entry in any of the entries in list 2 or list 3. VDS does not fall on any of the list. It is the state list or concurrent list. Hence, under entry 97 of the list 1, the parliament has a residuary power to act on the same. Again, once the legislature has the competency to legislate on the matter, the motive with which a tax is imposed is immaterial. This is with regard to the legislative competence of the parliament to enact section 115 BPH. Moving on to the second sub-issue, this council vehemently contends that it does not violate any of the fundamental rights enshrined in the Constitution. The legislature has made a very copious and a wide definition of VDA and has provided a definitional clause under section 2 clause 47A in the Income Tax Act to bring in VDAs and to separate virtual digital assets from other asset classes. Although the Constitution provides for the protection of equality, it does not predicate mathematically precise or logically complete or symmetrical classification. For prima facie, the classification is reasonable, hence not violating Article 14 of the Constitution. Moving on to section 91, challenge on the grounds of 19(1)(g), which deals with freedom for trade and profession. This council would like to reiterate what the co-council already discussed, that a high rate of tax rate of taxation cannot be a ground for unreasonableness and which is against the freedom of trade and profession. It is also well settled principle by a plethora of judgments that in a taxing statute, a legislature enjoys much more greater latitude for selection of subjects of taxation as also for classification, and that the legislative dispensation are based on an interaction of diverse economic, social, and policy consideration. The economic wisdom of tax is within the exclusive of the legislature, and the questioning of the legislative policy is beyond the scope of the judiciary. The rate of taxation, the quantum of taxation, the subject matter of taxation is with the legislative competence and the economic wisdom of the legislature, and any questioning or any disturbance in that will lead to judicial overreach and disturb the separation of powers enshrined in the Constitution. The council rests the argument on these grounds. And holds that the section 115 BBH is not violative of the Constitution. If Lordship has any questions, council is ready to answer.
You want to go first if you have any questions?
Yes. So we'll think about the maintainability issue, the second level, but could you answer what we were previously discussing with your opposing counsels also regarding the legality or validity of a provision of the competence to tax when the cost of acquisition cannot be determined by a taxing authority? The income taxer who will be taxing a particular acquisition, if they are unable to determine the cost of acquisition, then how is the income or the profit or gain on such an asset to be taxed? And whether that is legal?
In this case, Leadership,
Council, I'll also put my question, then one of you can answer that also. We'll put the question.
Definitely.
That way
Definitely.
it'll be clear and quicker. So my question would be, there is no parent act which is basically governing the cryptocurrency. Right now, the question is in the air whether it's legal or illegal. Supreme Court has struck down the fact that it is the circular by RBI saying that they removed the ban, basically, the Supreme Court. But still, for regulation of cryptocurrency, there is no act, but you plan to impose taxation on it. There are other activities having similar in the similar ambit, which can be termed as illegal, but they have been regulated properly, like gambling, betting, and they have a proper act which regulate them. Outside that scope, they are illegal, but within that scope, they are legal, and hence they can be taxed. Right now, here, this the electronic currency is not regulated by any act, but you are jumping the gun and going for taxation. My question basically is, how can you do that? Will that be legal?
Lordship, I'll be first answering Ladyship's question regarding the cost of acquisition. In this current case, as Ladyship have already discussed, cost of acquisition is quite clear in case of VDAs. Cost of acquisition is nothing more than the purchase price of VDAs, and it is allowed as a deduction. The case of BC Srinivasa Shetty seems irrelevant in this case. Is that the facts of the case are much more different than what is at hand. In BC Srinivasa Shetty, what was tried to be ascertained is the cost of acquisition of a goodwill. So it was a goodwill, cost of acquisition of a goodwill while the dissolution of partnership was taking place. So at that point in time, it was regarding an intangible asset that was discussed at that point. Whereas in case of VDAs, there's a clear-cut computation of cost of acquisition, which is the purchase price of an asset. With this regard to the first question, regarding the second question regarding no parent, regarding the parent act, Income Tax Department has tried to tax only the income rather than not regulate an entire sector itself. What is considered here is a transfer of a VDA, a gain on transfer of a VDA. So the Income Tax Department is concerned about only such gain and its taxation. If my co-counsel wants to add it.
No, as my co-counsel has reiterated, the main position of the government is to tax the gain or profits or which are arising out of the transfer, and as rightly it has been stated, not on the acquisition cost per se. So it is only out of the profit or gain which is arrived out of the transfer.
Yes, but how do you calculate the profit without subtracting the cost of acquisition, especially in light of the fact that the government has issued a clarification that cost of acquisition will not include the cost of infrastructure used for mining a cryptocurrency?
Yes, Lordship, in terms of infrastructure and mining, it comes under capital expenditure. Hence, capital expenditure cannot be allowed as a deduction for cost of acquisition. What is allowed is for the users of the VDAs to avail the deduction of cost of acquisition. Infrastructure, electricity, they come under capital expenditure option.
Yes, I understand. So in view of the fact that you are not permitting that as cost of acquisition, then in case of mining, you've answered in the situation where there's a cost of acquisition, like you're purchasing from somebody and then you're selling to somebody else, right? But this is a unique situation where there is also a possibility of creating it by the process of mining. So in those circumstances, how does the government propose to determine the cost of acquisition?
Cost of acquisition does not mean process of creating, Your Ladyship. Cost of acquisition is acquiring something, acquiring an existing asset. Whereas mining creates something new. It does not acquire an asset.
So those cryptocurrencies do not fall within the ambit of section 115 BBH?
No, it falls under the definition of TGA and hence under section 115 BBH.
So then in that case, you propose to value it at zero? Any cryptocurrency which is mined?
Yes, the cost of acquisition remains zero.
Okay. Well, that's I think. Is that the end of time or there's
Anything else you want to add? The first counsel to the queries, or is it okay?
No, I substantiate with whatever my co-counsel has stated. Co-counsel, he can proceed to the prayer, I guess.
The council seeks permission to move to the prayer. Wherefore, in the light of the facts presented, issues raised, arguments advanced, and authorities cited, the respondents humbly pray that the Honorable Supreme Court of Parliament find the arguments meritorious and discuss the writ petitions by the petitioners and dismiss the writ petitions by petitioners and pass any order, decree, or judgment the Honorable Supreme Court deems fit in the interest of justice, equity, and good conscience. All of which is humbly prayed. Thank you.
Any rebuttal from the petitioner?
A counsel for petitioner seeks permission if you can proceed with the rebuttal.
Please.
Yeah.
So Speaker 1 of the Council for Respondent spoke about the Cryptocurrency and Regulation of Official Digital Currency Bill 2021, stating that the government has passed this and they can tax on basis of this particular bill. Yeah, but then this was introduced in the Lok Sabha and is waiting for consideration. The government is yet to give approval on this or a clarity. This addresses the lack of clarity and confusion, as the government has not given a complete yes on it. Just because it is being introduced in Lok Sabha here, and this bill also seeks to prohibit the private cryptocurrencies in India.
Your Lordship, can I respond to this?
Please.
I think my learned opponents have understood me or taken me in a mistaken manner. I was referring to the RBI circular issued in 2021 and not to any bill which was introduced in the Parliament. There's a RBI circular in 2021 which clarifies the position with respect to the judgment of the Supreme Court, and that none of the entities under that regulated by RBI can use that 2018 circular to ban the activities of cryptocurrencies. Your Lordships, are we permitted to do Sir rebuttal?
I believe that was it. Is there anything else? They can do that, Court Master? They have
No,
time?
that was it.
That
They
was it,
rebutted.
right?
There's only
That's
one
rebuttal
answer.
to it, right? Okay, I believe we have concluded the proceedings.
Yeah, Your Lordships.
Yeah, Lordship, you can give feedbacks if you want. Advice.
Right. So, Satyasri, you want to start with that?
Go ahead, and anything else I'll add to it.
Right. So for like as a general, I would advise you guys were good. First of all, second, for your presentation, I would suggest be more calm. Don't be very flustered, especially when we ask questions. That is going to be a part of not just moot court. In the future, whenever you are practicing in court also, you will get questions. So don't get flustered. Take some time to understand the question and maybe 3-4 seconds to formulate the answer, and then you answer the query. But take the time. Don't be very don't jump into this entire, because what will happen is if you just jump into that entire question without formulating your answer in your own way, it will be jumbled up. You will not be able to put it across in a proper manner. So take your time, compose yourself, and then go forward with it. Otherwise, I guess Everything else was fine.
Yeah, you guys did a good job. One thing though is, especially for the petitioner side, when because you are starting with the arguments, don't assume that the judges know about what you're going to talk about, or the aspect of law that you're going to talk about, especially because this is a new area. And so it would be helpful if you gave a little bit of history about what it was and where you're coming from, in terms of what is the nature of a cryptocurrency and why that is different from other forms of assets, right? So that could form a good basis for your arguments. Others, as my colleague had said, be more calm and don't get flustered when a question comes at you. Sometimes it is to help you also to formulate your argument that you've already made in a better form. So don't think that if it's a challenge to you, sometimes it could also be to help you from the judges. So, yeah.
Right. I think that's it. Court Master, anything else which is required from us here?
No, you just have to fill this score sheet and mail it to the.
We will be mailing it to that email from, we'll just reply back to that email, right? The last
Yeah.
email which we received. Perfect, right. We'll be sending the scores. Great.
Also, the participants are supposed to leave. You're not supposed to find any other room as an audience.
Thank you, everybody. Thanks for
Good luck, everyone.
hearing.
Thank you. Good luck. Bye.
Thank you so much.